Well, hi everyone. Welcome to the Hard Answers. I'm Tom Graham. Here's a video for everyone that may have been approached by an anti-tax group or a group of sovereign citizens who don't believe that they need to pay their income taxes. The basis of the sovereign citizen argument is that the original Articles of Confederation are still being enforced and can still be referred to as law. This, of course, is nonsense, and here's why. We declared independence from England on July 4th, 1776, and started the Revolutionary War. The Articles of Confederation were adopted on November 15th, 1777, but were not fully ratified in all 13 states until 1781. The Continental Congress that the Articles of Confederation created could not pass laws unless they were passed unanimously. The Congress also did not have the power to tax the people, even though it had the power to emit bills. In other words, to print money. The Congress printed lots of money without having anything backing the money in order to fund the Revolutionary War, and people thought it was valuable for a time. When vendors found out that there was nothing backing the money, and that Congress had no power to tax the people to pay for the money, the currency became worthless, and the nation experienced hyperinflation. In 1787, Congress approved a plan to hold a convention in Philadelphia to revise the Articles of Confederation. As defined by the Articles of Confederation, modifications required unanimous consent from all member states. The delegates assigned this task quickly realized that they needed to start over from the beginning and invent a new form of government instead of amending the old. The Federalist and Anti-Federalist papers were published in newspapers across the country, bringing everyone up to speed on what they were doing and the pros and cons they were facing. Once the new Constitution was written, all 13 state conventions authorized by the Articles of Confederation accepted the change of ratification procedure, although only 11 state conventions approved of the document before its adoption. The Articles of Confederation had been modified by one all-encompassing amendment that completely replaced it, instead of smaller amendments that simply modified it. Although debate as to whether or not it was legally ratified when only 9 of the 13 states ratified it, the fact that all 13 states adopted it is proof enough that in practice it was ratified unanimously, just as the Articles of Confederation required. The U.S. Constitution replaced the Articles of Confederation legally and within the procedures defined by the Articles of Confederation. But even if it didn't, it wouldn't matter because now the Constitution was accepted by all 13 states. So now that we know that the U.S. Constitution was indeed ratified legally and properly and the Articles of Confederation no longer apply, let's go into why we have to pay taxes. The Constitution. Article 1, Section 1, representatives and direct taxes shall be apportioned among the several states which may be included within this Union, according to their respective numbers, which shall be determined by adding the whole number of free persons, including those bound to service for a term of years, and excluding Indians not taxed, 3/5 of all other persons. That was the 3/5 compromise for slaves. Article 1, Section 8. The Congress shall have the power to lay and collect taxes, duties, imposts, and excises, to pay the debts, and provide for the common defense and general welfare of the United States. But all duties, imposts, and excises shall be uniform throughout the United States. Article 1, Section 9. No capitation or other direct tax shall be laid unless in proportion to the census or enumeration herein before directed to be taken. The courts have generally held that direct taxes are limited to taxes on people, variously called capitation, poll taxes, head taxes, and property. All other taxes are commonly referred to as indirect taxes because they tax an event rather than a person or property per se. What seemed to be a straightforward limitation on the power of the legislature based on the subject of the tax proved inexact and unclear when applied to an income tax, which can arguably be viewed either as a direct tax or an indirect tax, depending on the source of the income. In order to help pay for its war effort in the American Civil War, Congress imposed its first personal income tax in 1861. It was part of the Revenue Act of 1861, which imposed a 3% tax of all incomes over $800. This tax was repealed and replaced by another income tax in 1862. In 1894, Democrats in Congress passed the Wilson-Gorman Tariff, which imposed the first peacetime income tax. The rate was 2% on income over $4,000, which meant fewer than 10% of households would have to pay. The purpose of the income tax was to make up for revenue that would be lost by tariff reductions. In 1895, the United States Supreme Court, in its ruling in Pollock versus Farmers Loan and Trust Company, held a tax based on receipts from the use of property to be unconstitutional. The court held that taxes on rents from real estate, on interest income from personal property, and other income from personal property, which includes dividend income, were to be treated as direct taxes on property, and therefore had to be apportioned among the several states. Since apportionment of income taxes is impractical, it had the effect of prohibiting a federal income tax on income from property. However, the court affirmed that the Constitution did not deny the Congress the power to impose a tax on real and personal property, and it affirmed that such would be a direct tax. Due to the political difficulties of taxing the wages of individuals and not taxing the income from property, a federal income tax was impractical. It was not unconstitutional, not impossible, just impractical from the time of the Pollock decision until the time of the ratification of the 16th Amendment. The 16th Amendment. The Congress shall have the power to lay and collect taxes on incomes from whatever source derived, without apportioning among the several states and without regard to any census or enumeration. The Supreme Court in Brushaber v. Union Pacific Railroad indicated that the amendment did not expand the federal government's existing power to tax income, meaning profit or gain from any source, but rather removed the possibility of classifying an income as a direct tax on the basis of the source of the income, for instance, rent of property. The amendment removed the need for the income tax to be apportioned among the states on the basis of population. Income taxes are required, however, to abide by the law of geographical uniformity, meaning that the tax has to apply to all states uniformly, without giving preference to any location over another. And that's why the United States government has the authority to tax your income. Of course, the next question is, has the government lawfully taxed my income? What is the exact law that says I'm liable to pay income taxes? That's easy too. The statute, U.S. Code Title 26, Internal Revenue Code. Subtitle A, Income Taxes. Chapter 1, Normal Taxes and Surtaxes. Subchapter A, Determination of Tax Liability. Part 1, Tax on Individuals. Subsection 1, Tax Imposed. And then, of course, you get questions like, is the IRC, the USC, and the CFR actually laws? Are statutes and regulations actually the law? Short answer is, yes, they are. Long answer is, there are 3 different kinds of laws. Statutes. These begin as bills, are debated in Congress, approved by Congress, and signed by the President of the United States. They are then recorded in the United States statutes at large, and then are codified once every 6 years into the USC, the United States Statutes Codified, also known as the United States Code. 50 books indexed by regulated subject. Book number 26, or Title 26, being the Internal Revenue Code, also known as the IRC. Statutes, once passed by Congress and signed by the President, can still be found to be unconstitutional by the Supreme Court. Regulations. These are the rules that are used to implement the statutes. They are proposed on the Federal Register, debated by stakeholders, and eventually implemented without the need for the President to sign anything. However, The President, through executive order, can unilaterally implement regulations and policies. Once implemented, they have the power of law, unless overturned by a court as contrary to law, meaning they expand beyond the authority of the existing law that they are implementing. This is why the courts were able to stop President Trump's original travel ban implementation. The lower courts found the regulation, the executive order, to be outside the authority vested in the executive branch by Congress through statute. Federal regulations are published in the Federal Register and codified every 6 years in the Codified Federal Regulations, the CFR, much like the statutes are codified in the USC. In fact, they both number the different titles exactly the same. CFR 26 contains the regulations that implement USC 26. How about that for a government organization? Judicial precedent. When any court makes a ruling, that ruling can be used as an argument for a lawyer in another similar case. When the Supreme Court makes a ruling, it is clarifying a legal issue because lower courts can't agree on the issue. And that clarification must be observed by lawmakers and law enforcers and lower court judges. In other words, the Supreme Court decides what the law means through precedent. So yes, barring a statute being found unconstitutional or a regulation being found contrary to law or outside the bounds of the law, statutes and regulations are indeed the law. And the books in which you find the laws are called the USC, the United States Statutes Codified, or the United States Code, and the CFR, the Code of Federal Regulations. USC Title 26 is also known as the Internal Revenue Code, or the IRC. Another argument is that there are lots of cases out there where a person is brought before a judge, charged with tax evasion. He makes the argument that he does not owe taxes, and the judge finds him not guilty of tax evasion. The anti-tax people seem to think that this is proof that the arguments the defendant made are true and the defendant has gotten off scot-free. Well, I guess that's one way to look at it, but let me show you the correct way to look at it. Our legal system has two branches, criminal law and civil law. The criminal charge being brought against the defendant is willful tax evasion. In order to be guilty of this crime, you need to understand that you owe taxes, and then willfully not pay them. I guarantee that in all the criminal cases being cited where the defendant is found not guilty of tax evasion, the judge found that the defendant honestly believes he did not owe taxes, and therefore could not be criminally punished and sent to prison for tax evasion, willful tax evasion. What you don't see is that the same defendant then has to appear in civil court, where the judge informs him that his understanding of the law is incorrect, that he does have to pay his taxes, and now interest and penalties have accrued. The IRS then takes all his assets because income taxes are not dischargeable in bankruptcy. I cannot say that the people pushing the "you don't have to pay income taxes" narrative are liars, but I can say that the words coming out of their mouth are demonstrably false. I hope that this has served to clarify the issues of why income taxes are indeed legal, what makes you liable, and why you should pay your taxes. For those of you who are still unconvinced, may God have mercy on your souls. Please click the subscribe button to see more videos like this. If you disagree with me, please leave a comment. My ears are always open and I learn new things every day when people disagree with me. I'm Tom Graham. I'll see you next time on The Hard Answers.